Namaste, everyone. Welcome to the Cārvāka podcast. This is your host, Kushal Mehra. All right. So today's podcast is going to be a two-part podcast. Today is part one. We're going to do another part on Tuesday next week. So to give you guys a brief background on in the year 2019, the government of India, through a presidential order, had basically changed the status of uh, the erstwhile state of Jammu and Kashmir by revoking Article 370. Post that abrogation was challenged in the Supreme Court of India, and it was being adjudicated by a five-judge bench. And recently, the Supreme Court five-judge bench, which was led by Justice Chandrachud, upheld the abrogation of Article 370, and they determined that the abrogation was legal because they said it was, quote, only temporary due to the unique situation that existed in the state of Jammu and Kashmir. They also stated in their decision that the president's order was not malicious and that Article 370 calls for the unification of Jammu and Kashmir rather than its breakup. So Nikhil and I decided that we will have to do a two-part podcast. Part one will be a kind of a look into what the history of the article is, what is the history of that area, why and how the legal journey has happened. And then part two will be taking over bits. We'll have bits of the judgment today, bits of the judgment in part two, and then in part two we'll also look at the opposition to it. Like I mean, I know Nikhil will not talk about the Pratap Bhanu Mehta one, but I will. And there is a Falim Nariman objection raised, and Nikhil is laughing because I told him कि Pratap Bhanu Mehta का article पढ़ना है तूने. He's like, मुझे भेजना भी नहीं. I don't take that stuff seriously. He only wanted the Fali Nariman article, so I sent him the Fali Nariman article because Nikhil has a lawyer's bias. So he's like, मैं सिर्फ वकीलों की चीजें सुनता हूँ. But having given you guys a brief background, now I hand it over to Nikhil. Nikhil, thanks for coming.
Thanks, Kushal. Great being here as always. Just to be clear about this is not because of a lawyer's bias or because I'm biased in any way against Mr. Pratap Bhanu Mehta, who I think is exceptional in a lot of other subjects. But this is such a deeply constitutional issue because today, that is why I want to read Mr. Nariman's comments and his son's comments, Justice R.F. Nariman's comments, because they are totally opposed to the judgment that is finally passed. And they make a distinction between, say, a political exigency which the judgment actually fulfills versus the interpretative jugglery, as they call it, that has been performed by the Supreme Court in order to uphold the abrogation, right? So I take that the purpose for me here today is I am not, if you are joining into this podcast to listen to generalities about 370, then this is not the podcast for you. This is actually going to be a very challenging and difficult podcast for any listener because I'm going to take you through a lot of the actual provisions of the Constitution and some very complex interpretations of the Constitution as were presented by the petitioners. So the purpose today for me is, one, I'm going to give you a very brief overlay of federalism under the Indian Constitution because this is where everything starts. Federalism essentially is the relationship between the union and the states, and how that relationship exists with every state, but why in the specific case of the state of J&K, certain exceptionalism was being propounded, right? Then I will go into a little bit of the history of 370 and how 370 was used, why there are arguments of the permanence of 370, and then we will end today by me giving you a detailed layout of the petitioners' arguments, because they are really the challenging arguments, and outlining the issues that the court identified and the issues the court decided. And in the next part, then I will look at the actual findings of the court, the actual judgment that the court rendered, and then along with that, various other commentary that we may see on the side, and we can comment on that, right? So I just wanted to start actually with a very basic understanding of what are we dealing with Article 370. And I actually found this, and I should credit them because this is actually quite an excellent timeline produced by the Supreme Court Observer. You can get this on their website of Article 370 from 1947 onwards. And I didn't really want to add more than what is here because they've somehow hit the sweet spot between giving great details without encumbering it so much so as to make it overtly dense and heavy. But they have links within this particular timeline that they draw out. And if you follow the links, then you can really go down a very, very interesting documentary rabbit hole, which will give you a lot of insight also into India's history around the period of independence, particularly how these states were formed, what was sort of going on at that point in time. And it's something that once you get into, it's a never ending thing, because one thing will lead to another, then you will want comparative analysis with other states, so on and so forth. But essentially, on 15th August 1947, J&K, Kashmir, the erstwhile Kingdom of Kashmir, had opted to remain independent, had not chosen between India or Pakistan. Every other state had chosen between India and Pakistan. Now, you may have arguments on whether this was done by force, legitimacy of various processes, etc. Whatever it may be, states had chosen. J&K had not chosen. J&K was given time to choose or to exercise one of its three options. When I say it has not chosen, it had also not declared any sort of affinity, one or the other. Not India, not Pakistan, and not an absolute state of sovereignty or independence either. So, in the absence of that declaration, there was a standing sort of stalemate between India, Pakistan, and Kashmir, in the course of which India and Pakistan were providing certain resources to Kashmir for the sustenance of the state while this determination was being made. And there was supposed to be a ceasefire. There was supposed to be total peace reigning in that region at that point in time. Now, in October 1947, and perhaps the preparation begins from September 47 itself, Pakistan attacked Kashmir. We say that this was done through what they used to call at that time Kabalis or local tribals, who were in the rhetoric of Pakistan, they were local tribesmen. We say that these were Pakistani soldiers and Pakistani regulars dressed as tribesmen. And this was a real simple attempt by Pakistan to usurp the state by force. So on October 26, 1947, Maharaj Hari Singh, who was the princely ruler at that time of the state of J&K. Now, just to give you a little bit of background, even British administered India had parts that were purely British administered. And then there were parts that they indirectly administered through the princely states.
Explain that. What does that mean?
So there are parts of India at that point in time which did not have a king, did not have a ruler. Delhi, for example, did not have a ruler. And that was directly administered by the British. So it is the British who are acceding Delhi away to the dominion of India. Right? But there are 565 princely states like Junagadh, like Hyderabad, like Kashmir, like various others, where it is the ruler who is giving an instrument of accession and a merger agreement with the dominion of India. Right? So that's a slight technical difference. And Kashmir being one of those, this was again a princely state with a ruler and was being administered by the British through the ruler. Now, on October 26, 1947, Maharaja Hari Singh signed the instrument of accession, acceding to the dominion of India. This is very important now. The Maharaja agreed to allow Parliament to govern three subjects and limited the Union's powers to foreign affairs, defense, and communications. Right? And everything else was supposed to be retained by the state of J&K, by the government of J&K. In fact, not a government, because he was supposed to stay in place. He was called the Sadar-e Riyasat. So the argument will be made, and this is why this fact is important, that there is a peculiar and special retention of sovereignty by Jammu and Kashmir, which is not common to any other state which signed an instrument of accession and a merger agreement, because J&K also does not sign a merger agreement. It only signs an instrument of accession. Now, this is 1947. Subsequent to this, our forces moved in and secured as much of Kashmir as we possibly could. Long story short, eventually you end up with a POK being lost in that sense, right? And in November 47, Prime Minister Nehru, in his ultimate wisdom, decides that he will call a plebiscite, but he had done this Because in the original meetings between Mountbatten, Sardar Patel and Nehru on one side, and Hari Singh on the other side, the issue of plebiscite was raised. Now, the Indian side had not accepted this issue of plebiscite, but it had also not protested against it because perhaps at that time the political exigency was, "Pehle let them come in and then we'll deal with these things." Right? So we hadn't accepted, we hadn't rejected. So there's that famous anecdote of how Sardar Patel was almost chasing after Nehru to stop him from making this announcement on All India Radio and then thereafter taking it to the UN. But even in the UN, the resolutions that were passed, and I'm just giving this as a point of historical backdrop, this really doesn't have much to do with Article 370 now, but just as a point of historical backdrop, there was to be again a ceasefire. There were certain conditions that were necessary that had to be maintained. Those conditions stood violated by Pakistan time and again. And so, therefore, those resolutions themselves of the UN hold no water anymore. And in fact, a very pithy and simple analysis of this is done by Christine Fesch. She does a very good analysis of it. But you can find various videos of her on social media circulating where she sort of demolishes the Pakistani argument of the resolutions before the UN. Be that as it may. So this is 47. There's an instrument of accession, and only 3 subjects are given to India. 26 January 1950, our constitution comes into force. Now, Article 370 then sets out a broad framework. Article 370 stipulates that India would not make laws in Jammu and Kashmir outside the scope set out by the instrument of accession without the concurrence of its government. Further, it stated that except Article 1, which declared India the union of states, right? So a certain status is given to J&K. It is not called a Sadr anymore. It is not called a Riyasat anymore. It is now a state of the Union of India under Article 1. But other than Article 1 and Article 370, no other article of the Indian Constitution was to apply to the state of J&K. However, Article 370 within itself had a mechanism by which provisions of the Constitution from time to time could be applied to the state of J&K, given that you receive concurrence from the state government there. Right? So the idea was, at that point in time, perhaps, and this is what the judgment eventually deals with, that given the peculiar circumstances of the time, you were only inserting provision of the Constitution as applicable to J&K from time to time after concurrence being received, and not as is the case with every other state where ipso facto the Constitution applied to you. Right? The President of India could make any provision of the Constitution to apply to the state with modifications or exceptions, but required only in consultation with the state, with the government of the state. It could not, and Article 370 could not be amended or repealed unless the Constituent Assembly of J&K consented to it. This is very important. The status of the Constituent Assembly of J&K. And this comes into Article 370, subclause 3. And a lot of what we will discuss today really revolves around the few words in Article 370, subclause 3, which changes everything. And a very elaborate legal mechanism is adopted by the Union of India eventually to circumvent all of these problems. But I just wanted to make the point that at the time at which we first came into an accession with J&K, in fact, there was a very, very limited accession. And that's an acknowledged fact. Nobody can contest that fact.
Limited accession matlab kya? As in?
That there were only 3 subjects on which the Union of India could make laws that would apply to the state of J&K.
Got it.
Right? And why is this different from other states? Because, and this is where there is a natural bridge that is drawn between federalism as I'm describing it in the context of J&K versus federalism generally in the Indian Constitution. And generally in the Indian Constitution, under Article 254, Parliament has the right to make certain laws. So does the state legislature. And there is a concurrent list. And the lists, the way they are drawn up, are housed in Schedule 7 of the Constitution of India. And List 1 is a set of legislative entries on which only the union government can make laws. There are 96 entries on which only the union government can make laws. And entry 97 is what we call a residual power. And I want you to bear in mind this residual power. Because effectively what that clause 97 says, entry 97 says is, whatever else is not covered by any other entry, in any other list will be a power of the union government, right? Because you will repeatedly in the course of this particular uh, podcast and in generally in dealing with 370 constantly hear the term residual sovereignty, right? So for every other state, the concept of residual sovereignty under the list was crystal clear would fall to the Union of India. Just to give you a flavor of what I'm talking about,
So everybody should remember these words: residual power for
residual
the benefit
sovereignty,
sovereignty.
and residual power, right? So, for
Yeah.
example, atomic energy, arms, firearms, naval, military, and air force, delimitation of cantonment areas, foreign affairs, United Nations organizations, foreign jurisdiction, extradition, pilgrimages to places outside of India, railways, highways declared by law, maritime shipping, lighthouses, port quarantine, airways, property of the union, court court awards for the estates of rulers of Indian states, Reserve Bank of India, foreign loans, trade and commerce with foreign countries, interstate trade and commerce, very importantly, all fall with the union. These are, I'm just giving you a flavor. And entry 97 says any other matter not enumerated in list 2 or list 3, including any tax not mentioned in either of those lists. And list 2 is the power of the states, right? And so public order, police. Police is the one that we always have a fight on, right? We keep saying, why doesn't Modi government reform the police? Well, he can't. The power lies with the state.
In fact, in Delhi also the police thing is so weird, right? Between the state and the central relation.
So that is because of certain provisions of the constitution by which statehood was granted to Delhi. But even today, the Delhi police answers to the Ministry of Home Affairs.
Yes.
Right? So I'm just giving you a relief of the disabled and unemployable, burial and burial grounds, cremation and cremation ground. All of this falls with the state. Land, right in or over land tenures, including relationship of landlord and tenant, all falls with the state. And then there's the concurrent list. And the concurrent list is an interesting entity. The concurrent list is essentially subject matters where if Parliament legislates, then Parliament is supreme. The state may legislate, but if and the state that's why it's called concurrent. Both can legislate, but any legislation that the state makes, right? If that legislation is contrary or what we call in law as repugnant to the parliamentary legislation, then the parliamentary legislation will prevail, save and except one circumstance that if that particular state legislation has been accorded presidential assent.
Hmm.
Right? And here you will get criminal law, criminal procedure, preventive
So
detention. So, for
keywords
example,
are presidential assent over here
that's
to
right.
remember.
Right. So,
Just
for
telling
example,
everyone to remember the presidential bit.
criminal law and criminal procedure, for example. Now, people know of the CRPC, people know of the criminal procedure code, people know the 3 new laws have been passed now by Parliament, by Lok Sabha, not yet by Rajya Sabha, but by Lok Sabha, which will replace your IPC, your Indian Penal Code, your CRPC, which is your Criminal Procedure Code, and your Indian Evidence Act. Those 3 will be replaced, right? But in all 3, in particularly in the Criminal Procedure Code and in the IPC, you used to have state amendments. And those state amendments were enforceable and applicable in relation to offenses that occur in that state, provided that those amendments were not repugnant to the main section passed by Parliament. That's all I'm trying to point out over here, right? So, this is just to give you an idea of how sovereignty sort of operates. So, for every other state, the lion's share of legislative power goes to the center, whether through list 1 or list 3, and the residual power also goes to the center with a limited set of laws that can be made under list 2. And that is why India is never regarded as a federal state. It is a quasi federal state at best, but with a deeply central power mechanism, deeply centralized power mechanism. Now, under Article 370, subclause 1, you spoke of presidential orders at the start, right? We call them
Hmm.
constitutional orders. And the
Hmm.
ones that we are talking about are Constitutional Order 272 and 273. So, Constitutional Order 272 and 273, you can deem to be the last constitutional order under Article 370, because after that, the article is gone. Right?
Okay.
But that implies there were 271 preceding constitutional orders.
Hmm.
And what was this? I had said to you at the start, only three legislative spaces were granted to the union and the instrument of accession.
In
But a
1942.
technique was devolved in Article 370, subclause 1, by which other provisions of the Constitution could be enforced upon the state of J&K. And so these preceding constitutional orders are small, small things that are slowly being added into J&K from the Indian Constitution,
Got it.
right? And the most significant of these, where the union was initially given only three powers, right, was that list one was pro tanto, as it stood, added into J&K. This list one that I just described to you, the legislative powers of the union, was applied to J&K. This happened sometime in the 50s,
Okay.
right? And if you allow me to share screen,
Sure.
uh, sorry, let me first.
You want
Do I
me
go to
to
do I go
you
to
just have to
settings?
go. No, you have to click present and just click share screen. You have to choose the tab you want to share and it will pop up.
Right? So you can see this.
Yeah, I'll put it up now. Yeah.
Orders issued under the Constitution of India.
Mm-hmm.
And I just, there's not a lot I want you to go through.
Okay.
Just this table of contents,
Got it.
right? Distribution of revenues, determination of population, scheduled tribes order, order under 343, that is language, sort of central control, all kinds of stuff is slowly being added in and added in and added in, right? And there are some of these do not relate to J&K in particular, but several of these relate to J&K. For example,
Hmm.
look at 81, Scheduled Tribes Order in relation to J&K. Uh, and as we keep sort of scrolling down, this is an older list, for which reason it ends at 158, right?
Got it.
We can close this. I'm stopping the screen now.
Yeah.
That's just to give you a feel that this is how the mechanism was devolved. Now let's be clear, therefore. With the instrument of accession, power vests in J&K. 370 subclause 1 allows you to add in as and when you require. But if you
Got it.
don't add in, the power remains there.
That's the by default assumption.
That's right. The default
Okay.
position is the IOA, the
Okay.
instrument of accession. Now, in 1951, 75 members of the. Now, this is very important. In no other state, because instruments of accession of J&K are exactly the same as the instrument of accession of every other state. But every other state has a merger agreement. And no other state forms a constituent assembly of its own and forms a constitution of its own.
Unlike Jammu and Kashmir.
Yes, J&K is the only state. And in 1950, late 1950, uh, and in 51, the Constituent Assembly of J&K was formed. On October 31st, 1951, 75 members of the J&K Constituent Assembly gathered for the first time. They belonged to the National Conference Party led by the Minister of J&K, Sheikh Abdullah. Their goal was to draft a constitution for Jammu and Kashmir.
Hmm.
Right? Then
What,
in
what
50,
was that famous line? एक देश में दो विधान, दो प्रधान और दो निशान नहीं चलेंगे. It was
see,
basically about this,
that's
right?
the opposite argument, right? That's the
Yeah.
opposite argument. But the argument on behalf of those who want to uphold 370 as it stood was to say that 370 is the only bridge between the Union of India and state of J&K. That absent 370, there is no other bridge between the Union of India and J&K. So in 52, the Delhi Agreement was signed between the government of India and the government of Jammu and Kashmir. It concerned the residuary power, that is Article 248 of the Parliament, that fell outside the scope of state or concurrent lists. The Delhi Agreement stated that such powers would be vested in the hands of the government of Jammu and Kashmir. So your entry 97 stays with the government of Jammu and Kashmir, unlike with every other state where entry 97 goes to Union of India. Typically, the Union Parliament exercises all residuary powers in other states. Delhi Agreement also extended some provisions of the Indian Constitution to the state, namely fundamental rights, citizenship, trade and commerce, union elections, and legislative powers. These are all very important. Citizenship, in particular, is very important. You still,
Hmm.
even if you may be from JNK, you operate on an Indian passport,
Passport, yeah.
right? Prime Minister Sheikh Abdullah in the Constituent Assembly stated the residuary powers vested in the centre in respect of all states other than Jammu and Kashmir. In case of our state, they are vested in the state itself. This position is compatible with Article 370 of the Indian Constitution and the instrument of accession on which the article is based. We have always held that the ultimate source of sovereignty resides in the people. It is therefore from the people that all powers can flow. I am reading all of this because this history will tend to indicate that in fact there was a very good and strong case against the non-abrogation of 370, right? Particularly at that time. And if there are viewers who are logging in today in the hope that I'm going to try and demolish the arguments against Article 3, today is not that podcast. Today is the podcast that will build up the arguments against the abrogation, right?
Hmm.
And it's in the second part that we will take those arguments down, because I think all of these things require a very specific kind of detail. Otherwise, you can just turn around and say, look, political act at that time, political act at this time, whatever constitutional machinery you exercise, who cares? We don't care. That's the end of the matter. And that really isn't a podcast at all. That really doesn't give you the details of what was affected, because
To-
what was affected was very, very interesting.
Today's podcast is a Purva Paksha. Tuesday's podcast will be an Uttar Paksha.
Something like that. Yes.
Yeah.
Now, in 1954, President issues the Constitutional Order of 1954, which implements the Delhi Agreement. So, President Rajendra Prasad issued the presidential order to implement the terms agreed to in the Delhi Agreement of the Indian Constitution. The presidential order guaranteed territorial integrity to JNK and introduced Article 35A, which conferred special rights to permanent citizens of Jammu and Kashmir. This order was passed with the concurrence of the Constituent Assembly of Jammu and Kashmir. This 35A is a thing that often sits very badly with a lot of people, particularly my mother, because that is where the concept of domicile in JNK arose. And if you, for example, were a citizen of JNK and you married out of JNK, you were no longer a citizen of JNK. You could not hold property. You could not have certain rights within JNK. In any event, move forward.
Yes.
And then we come to 1957, and this is a very, very important date in the context of the arguments that you will hear. After a 5-year process, on January 26, 1957, the Constitution of Jammu and Kashmir came into force with a declaration. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. The day before that, on January 25th, 1957, having completed the task, they were formed for the Constituent Assembly, dissolved at 12 p.m. noon. Very, very important. Constituent Assembly dissolved on 25th January 1957. Right? Now, the President of the Constituent Assembly, Honorable Ghulam Muhammad Sadiq, announced today the historic session ends. And with this, the Constituent Assembly is dissolved. The Constituent Assembly made no express recommendation to dilute Article 370. Please remember this always. Because the argument that will be raised is, if it was in anybody's power to abrogate 370, it was only this Constituent Assembly and no one else.
Yeah.
Right? Now, in 1959, there's a very famous judgment in 1959 that becomes a very contested judgment even during the course of these hearings.
What
In
is the name of
Premnath
the
Kaul,
judgment?
Premnath Kaul versus Union of India, the Supreme Court highlighted the significance of the final decision of the Constituent Assembly of Jammu and Kashmir under Article 370, Subclause 3. This provision mandates that a declaration by the President is subject to approval by the Constituent Assembly. The case involved the constitutionality of the Big Landed Estates Abolition Act of 1950, which was challenged by the petitioners on the ground of the Maharaja of Jammu and Kashmir, who enacted the act, lacked legislative power to do so. The Supreme Court upheld the act, ruling that the Maharaja indeed possessed legislative powers to pass it. And this judgment becomes something that we will keep visiting again and again, because this now starts to enter into that territory What are these so you started to impose articles of the constitution into JNK, but now how do you interpret the two together? Because really, there are very few circumstances in which you are not a federation of states, okay, where two constitutions exist alongside. The
Hmm.
United States, for example, every state has its own constitution. They were a federation, they are a federation, therefore. But the
Yeah.
powers are so cleanly divided because this was the case from the start,
Yeah.
right? And there, the residual powers are always with the state. So, if in effect
Always.
JNK was trying to take that kind of status for itself, which is different to all of the other states,
Hmm.
right? And in fact, the perfect federation of states was actually the CIS that was formed after the former Soviet Union was dissolved.
Hmm.
And the big difference there is the power to secede.
Yes.
If anybody wants to read, I'm not going to go into details on this, but if you want to read on what are the elements on which federalism is determined by legal scholars, this is the ultimate person you have to read is a guy called Ivo Dukacek. Ivo Dukacek set out certain parameters on which the federal character of a constitution is analyzed. And the Indian constitution, I think there were 17 factors. Indian constitution perhaps meets 6 or 7, 7 or 8 at most. The American constitution is higher. The CIS was nearly complete.
Hmm.
And if you look at modern day Europe under the EU, it's perhaps even higher. But more of a novel sort of structure because there is no centralized government that can override powers there in a real sense. Anyway, now in 62, Supreme Court held in a judgment called Puranlal Lakhanpal versus the President of India that the president has wide powers to amend constitutional provisions in Jammu and Kashmir. A presidential order allowed Jammu and Kashmir to be represented in the Lok Sabha only through indirect elections, while other states are direct elections. The order modified the application of Article 81, which pertains to the composition of the Lok Sabha to exclude Jammu and Kashmir.
Hmm.
Petitioners challenged the order, contending that the president can only make minor modifications to constitutional provisions. The Supreme Court upheld the presidential order, stating that the word modification in Article 370 should be interpreted broadly to include even an amendment. The court held that the term modification should be given the widest possible amplitude within the context of Article 370. Now, this is very, very interesting. You cannot do this to any other Indian state. But because you are applying Article 81 to JNK through the route of Article 370 subclause 1, you are allowed to modify Article 81 when you are applying it to JNK.
Hmm.
Right? So it's a very, I'm just reiterating this stuff because it's a very peculiar relationship. It doesn't exist in any other known circumstance. Right? And what comes about then is that in 68, this is the competing judgment. Okay, so what happens when the petitions are filed challenging this abrogation? Abrogation occurs through steps on 5th and 6th August 2019. The Venerable Dr. Shah Faisal, as petitioner, files a petition on August 19th, right?
Hmm.
Who has now come back to the fold of the union government and the IAS very recently. I think a few days ago, he's been announced,
Hmm.
right? Now, I had read to you the earlier judgment, which was, sorry, getting the name.
The Premnath call
59
one.
judge. Yes. So, this judgment, Premnath call, is often cited for the proposition that 370 is temporary.
Hmm.
And it can be modified in its language in various ways. That's the proposition. So Premnath call was used a lot by the union.
Yeah.
But the competing judgment is Sampat Prakash versus State of Jammu and Kashmir. The Supreme Court dealt with the constitutional validity of two presidential orders extending the application of Article 35C in Jammu and Kashmir. Article 35C was a special provision which provided immunity to preventive detention laws from fundamental rights claims in the states. The petitioner argued that Article 370 ceased to exist after the dissolution of the Constituent Assembly, and therefore the president was no longer empowered to make orders under Article 370 subclause 1. Now, this is very interesting. The argument was actually even 370 does not exist anymore. The word temporary in the context of 370 was only to facilitate the relationship with the Constituent Assembly. And once the Constituent Assembly of the state had determined that, in fact, they have now a new assembly, and then they have a new constitution in place for the state, and they have not abrogated 370 in that sense, or not said that all of the Indian constitution, all Indian laws will apply. That means 370 has no further role.
So
Right?
basically, this only helps the Union of India. Na? How does it help
No.
anyone else?
It would go totally against you, because then it would say that that total sovereignty lies with the Constitution of J&K.
Okay.
That was the argument, right? And here's the interesting bit. So, to be able to circumvent that, the Indian Supreme Court then says, no, 370 is a permanent measure. So please understand that the sense in which the Supreme Court first says 370 is a permanent measure is actually for the preservation of 370 in order to extend further powers of the Indian Constitution into J&K. And Indian laws into J&K. That's the context in which they say 370 is a permanent measure. But today, that same statement out of context is used from that judgment to say, oh, it becomes a permanent measure, means there's nothing else that you can do about it at all. Right? So perhaps the union is correct in saying the interpretation being given in this judgment in Sampat Prakash to 370 by the Supreme Court was that this is always a gateway provision. And the gateway effect of that provision does not go away after the Constituent Assembly of J&K is dissolved.
That is a matter of interpretation, right?
No, there's no matter of interpretation there. That's no matter of interpretation there. What they are saying is a very simple thing. 371, subclause 1, allows you to impose certain laws into J&K from our constitution and from our domestic laws, right? That is the bridge that allows this to happen. In this judgment, they go and say, sorry, Constituent Assembly was framed. Constituent Assembly now decides that J&K constitution is supreme. Therefore, even 370, that route is shut. And no law from India can now be applied into J&K. To dispel that, the Supreme Court says, no. It is all it's a permanent provision, and therefore that route will always be open.
Got it.
But the context in which it is now being used is different. Because the context in which now it is being used is to say, therefore 370 becomes non-abrogable.
इसीलिए तो मैंने तुझे बोला ना कि the moment you read it, I was like, this is going to be used by the government to help them.
No. So the judgment itself, yes. No. Those will go back and forth a little bit, but the core provision of it being non-abrogable is being used by the petitioners. Right? Now, what happens is this. Just going to leap forward a little bit. In Shah Faisal's initial petition, this conflict between the Pannalal Kaul judgment and the Sampat Prakash judgment is cited to the court. That one says temporary provision, the other says permanent provision. Right? And therefore, there is a conflict between the two. And therefore, please place this before a constitution bench. And that is how the constitution bench arises. But the court is wise to the argument that I just explained to you, that the context in which it was called permanent. So there are certain paragraphs that are related into the judgment saying that even that court was saying, boss, what are you talking about? The first question that court raises, what amounts to a conflict of judgments? When is it feasible to make a reference to the to a constitutional bench? In fact, is there a conflict between these judgments at all? Right? In any event, in 72, and this is quite crucial, because this is one of the mechanisms used eventually by the Union of India. The Supreme Court holds that the president can amend interpretation of certain words through Article 370. Right? In the case of Maqbool Damno, it's an interesting judgment. This judgment, again, the way both sides use it, it doesn't travel as far as both sides wish to use it. But where it does travel to creates a problem for everyone. Because what it effectively does is this. Everybody tried to argue from J&K saying, look, The proviso to Article 370, subclause 1, subclause D says you must get the consent of the Sadr Riyasat. Right? There is no Sadr Riyasat. Therefore, there can be no more consent. Therefore, no more laws can be applied to JNK.
What a
And the
plan.
Supreme Court turns around and says, Bevkoof mat banao hamara. Sadr Riyasat is gone, but the successor of the Sadr Riyasat is the governor and the council of ministers, and so if and the legislative assembly, and if they give assent, then everything can be done. So that is again, we keep coming back when we did the basic structure podcast as well. Literalist interpretation of the constitution versus a interpretative interpretation of the constitution. This or an enabling interpretation of the constitution. This is more enabling. That is to say, you cannot be stuck with a non-existent reality and say that a constitution ossifies because of the absence of that current reality.
Hmm.
The petitioner challenged the order, arguing that it lacked the recommendation of the Constituent Assembly, which had already been dissolved. The Supreme Court upheld the validity of the presidential order. The court viewed the amendment as a mere clarification since the office of the Sadr Riyasat no longer existed. According to the court, the governor had succeeded the Sadr Riyasat. But be very mindful. In this judgment, although the union tries to use it in that manner, the court does not interpret what the meaning of the word Constituent Assembly in Article 370, subclause 3 is. Okay, they only go as far as Sadr Riyasat, but the logic of it will be the same, because what the union is saying is, look, Sadr Riyasat goes away, and you say effectively it's the governor. Same way, if the Constituent Assembly goes away, effectively now it's a legislative assembly. How does it matter? This will make more sense when I come down to what all was done by the government. Step by step, it's a very interesting, and I mean, speaking for myself, दाद देनी पड़ेगी यार. What a ploy. Now 72 के बाद
मिस्टर
we come
जेटली
to
ने ये
20,
प्लान किया था.
perhaps that's what I'm told. Now we come to 2016. 2016, very important judgment again of the Supreme Court. There is a Sarfasi Act. I'm sure a number of your viewers who have otherwise taken loans from banks, etc., would be aware of the Sarfasi Act. Sarfasi Act essentially arose at a time at which, this is a little on the side, but just to give you some legal background, right? Now that it's come up, it's interesting, and I just want to say it. The first attempt made legislatively in India to go after bad bank loans was to set up tribunals in the hope that by setting up tribunals, you will be able to dispense justice very quickly. And so therefore your debt recovery tribunals were set up. And you will be able to recover monies owed to the banks. But we soon realized that हमारा जो court system है, आप चाहे 10 नए किस्म के बना लो, वो end में फंस ही जाता है. So because वो फंस जाता है, and that court system becomes so slow, you now needed laws that gave more draconian powers to banks to act. So the Sarfasi Act was enacted, which essentially allowed them to go and pick up the asset itself and start selling it. And then you are the one challenging the sale of the asset. Right? So in that context, they say that the Supreme Court addressed a challenge against the Sarfasi Act, a union government legislation. The petitioners contended that this act clashed with the Jammu and Kashmir Transfer of Property Act, legislation specific to JNK. The Supreme Court upheld the union's legislation. During the hearing, the Supreme Court observed that there was no definitive timeline mentioned for the operation of Article 370. The provision would continue to be in effect until a recommendation from the Constituent Assembly. In every judgment so far, nobody has still touched Article 370, subclause 3. Okay, I'm just going to read this, and the next thing I'm going to do is read for you Article 370. And I'm going to ask you to, the unamended old 370, just put it up on screen. If you can do that now, let's go through it straight away.
Yeah, I'll put it up. Give me a bit. I'll put it up, but I'm just trying to look for it. I had opened it, but कहाँ गया वे? 357 है, 368 है. Oh, yes, 370. Okay, I'm going to put up the 370 from constitution.net so that everybody can look at it. And here you go. So this is 370. Let me make the screen even larger so that people can read it comfortably. So This is your article.
One sec. Stop scrolling. Stop scrolling. You
Yeah.
see that first word, notwithstanding anything in this constitution, right?
Yep.
These are what we call as non-obstante clauses.
Hmm.
This is the broadest kind of non-obstante.
Okay. Explain this word because nobody might know.
Notwithstanding anything in this constitution means whatever else your constitution may say does not apply to this article.
Okay. Got
Because
it.
some of the things that you are trying to do in this article will otherwise be in conflict with other articles. So you are creating a limitation of judicial review, which says effectively non-obstante means you cannot look into clashes between this article and other articles of the Constitution.
Hmm.
And this people should bear this in mind because this argument will come up later.
Got it.
Anyway, notwithstanding anything in this Constitution, the provisions of Article 238 shall not apply in relation to the state of Jammu and Kashmir. Now, what is 238? 238 is 238 was actually eventually deleted, so it doesn't matter. This was uh, deleted in 56, so it doesn't matter. This bit is not the difficult bit. The
Mm-hmm.
power of Parliament, now B, power of Parliament to make laws for the state shall be limited to those matters in the union list and the concurrent list, which, in consultation with the government of the state, are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India, as the matters with respect to which the Dominion legislature may make laws for that state, and such other matters on the said lists as with the concurrence of the government of the state, the president may by order specify. This is where your presidential orders come from, right? But that first bit, those matters on the union list and the concurrent list, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession. Which meant what? Instrument of accession said only three things will apply,
Hmm.
right? So, in clause 1, immediately on the instrument of accession, all powers that relate to those three things that were given in the original instrument of accession, the Union of India has the power to make laws straight away.
Hmm.
And just to go back to that, those three things were foreign affairs, defense, and communications.
Hmm.
So these can be divided into a number of entries, right? So a number of entries and laws you made under these will have application immediately. But look at part 2 now. And 2. Such other matters in the said lists, as with the concurrence of the government of the state, the president may by order specify. This is where your presidential orders come from.
Yeah.
Which say
Exactly. I was gonna say.
other matters meaning those matters that don't correspond to the instrument of accession.
Hmm.
Therefore, 370 subclause 370 subclause 1, subclause B, subclause 2 already contemplates that you can travel far beyond the instrument of accession, but
Hmm.
it is a consensual procedure. And this is where I had specified that by the use of this, the entire list 1 of 7 schedule, that is the entire powers of lawmaking of the Union of India, were enforced in JNK.
Hmm.
Other than that,
अब
entry 97.
अब समझ में आया.
Right?
Hmm.
Now, for the purposes of this article, the government of the state means the person for the time being recognized by the president as the Maharaja of Jammu and Kashmir, acting on the advice of the Council of Ministers for the time being in office under the Maharaja's proclamation dated 5th day of March 1948. अब महाराजा जी तो बचे नहीं,
Hmm.
तो
So
Maharaja
governor.
becomes governor. That's what that judgment had
Governor.
said.
Yeah.
Correct? So you are now lending meaning to the words of this article that are different from the words that existed. This is where I come back to that interpretative, enabling interpretation of the Constitution. Right? Now, subclause C, the provisions of Article 1 and of this article shall apply in relation to that state. I told you from the beginning that when the instrument of accession came in, it was crystal clear that whatever else may apply from the Indian Constitution, Article 1 and Article 370 certainly apply. And
Hmm.
that means that Article 370 is the only route by which anything else applies. That's the argument.
Hmm.
And how does it apply? We go back again just so that sometimes repetition is necessary in these things. Scroll up again.
Okay.
Article 1 and Article 370 apply. If you can scroll up a little bit, right? So that go up a little bit more.
This is it.
Stop. Article 1 and Article 370 apply. 370 says, subclause 1 again, from the moment you arrive into the Indian Constitution, into the Indian Union, you are now subject to those three powers under the instrument of accession. All legislative power goes straight away to the Union of India. And you will identify entries from entry 1 from list 1 of Schedule 7 that correspond to those powers, right? So that immediately happens. And if you want to extend further, you will go to 2. That's the
Hmm.
purpose of C. Now come to D, and D is the killer. Such other provisions of the Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now we have seen Article 81, that judgment in the context of Article 81, where
Hmm.
modification was, no, I'm sorry, you're going to have only indirect elections. You're not going to have direct elections.
Hmm.
That same Article 81, if you had tried to impose on the states would have said not possible without an amendment to 81.
Hmm.
So, what would in Article 81 be required by way of a substantial amendment under Article 356 of the Constitution, under Article 368 of the Constitution, right? Can be done by way of a simple presidential order in the context of JNK,
Hmm.
right? So, now what happens is, now these two provisos are very important. Well, this is where the whole battle happens. Such other provisions of the Constitution, such other provisions of the Constitution shall apply in relation to the state, subject to such exceptions and modifications as the President may by order specify, provided that no such order which relates to matters specified in the instrument of accession of the state, referred to in paragraph 1 of subclause B, shall be issued except in consultation with the government of the state. Okay? And provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. So, to apply portions of the Indian Constitution or portions, and by saying portions of the Indian Constitution, I mean legislative power of the Union
Hmm.
into the state of JNK, you needed the consent of the state government. And in this context, think of the politics of JNK. After having worked with Sheikh Abdullah for a long time, Prime Minister Nehru had imprisoned Sheikh Abdullah for a large period.
Yeah.
They had the government. So the government was constantly giving consent.
Hmm.
These constitutional orders are being passed. Now, clause 3. Oh, sorry, first clause 2. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of the clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision as it may be taken thereon. This is very important. What is it saying? It's saying, supposing you have given, there is a time period gap between the joining uh, of JNK into the Union, the coming into force of the Indian Constitution, that is on 26 June 1950, right? There is a 1 year period until on the 26th of oh no, in fact, even a longer period, 18-month period or so, in which the Constituent Assembly of JNK is established. In that 18-month period, if certain consents have been given,
Hmm.
right, as I read earlier, I hope you're getting this. If you're not getting this, I'm
Yeah.
sure the viewers are not getting it. But
No,
if
I'm
certain
getting it.
consents have been given at that time, those will have to be placed before the Constituent Assembly for its consent.
In fact, now I've understood how the government went about removing this thing. I'm so
Yeah.
proud of the government.
Now
Yeah.
comes clause 3. This is very
Yeah.
important. Notwithstanding anything in the foregoing provisions of this article, the President may by public notification declare that the article shall cease to be operative or shall be operative only with such exceptions and modifications from such date as he may specify. So this is the power of the President.
Yeah.
But
Base.
provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues a notification.
Hmm.
Right? Very
Hmm.
interesting stuff. Power of the
Okay.
President, but can't do it without the Constituent Assembly. Now we come to
S- See, the
The
basic
fun bit.
question here, everybody should remember two, three things in this. I just want to remind people. What Nikhil is doing is trying to explain how 370 was structured. इसमें दो तीन पॉइंट्स बहुत important याद रखना. Power of the president and constituent assembly. These two words, always remember this. And now,
And
if you're
most
smart enough,
importantly, concurrence of the state, concurrence of the
concurrence
constituent.
of the state. Okay, now these three things, think how 370 was removed. If you're smart enough, you will understand what the government did.
No, no,
It's
it's
what you
actually
can call the state at a particular point of time.
quite complex for people to sort of decipher like this. Broadly, they'll say, "हाँ यार, consent वगैरह के provisions हटा दिए होंगे," but कैसे हटाए, right? Because that is what is being tested. When you remove these things, how do they stand up to constitutional scrutiny? And what is the
Hmm.
route you choose to remove these things? For
Hmm.
example, every single article of this constitution is amended only under Article 368. But this particular provision has its own mechanism for amendment, which is in Article 370.
Hmm.
And unlike other articles, which requires both houses of parliament to pass an amendment, and perhaps even more than that in the case of certain amendments, this one just says the president may declare, but if the constituent assembly accepts.
Hmm. Uh, it needs a constituent assembly.
Right? So the argument that comes from the petitioner is always 370 is a standalone thing.
Hmm.
Starting with that non obstante that I read in the beginning, notwithstanding
Yeah.
anything contained in this constitution. Right. Now
Hmm.
let's go step by step about what was done. On 19th of June 20, these dates are important. They'll be important in a larger context as well. But on 19th of June 2018, Mehbooba Mufti resigns. This now I'm reading my own notes. Huh? I'm done with the
Hmm.
Supreme Court Observer and I'm very grateful to that lovely history that they had recorded. But this is now my own notes from various things that I've picked up. Uh, on 19th of June 2018, Mehbooba Mufti resigns after the BJP government withdraws support. Right? And look at the alacrity. And if you think this was not planned on that day or before that day, then you're about to cotton onto something that you'll find actually, if you're on this side of the divide, quite amusing, otherwise quite sinister. Depends on how you look at things. Immediately on the 20th of June 2018, Governor issues a proclamation under Section 92 of the J&K Constitution, which allows the governor to be entrusted with all power of the state government. President of India provides his concurrence. Proclamation is to last only 6 months. Okay. We have a parallel provision in Article 356 for every other state. But I'll tell you about
Hmm.
that. Now, this is very interesting because what would happen if a coalition government falls in any other state? You would be allowed to do a floor test if every other political party gets together and says, no, in fact, I have majority. Right? And this is why an argument is constantly raised. Look at the alacrity with which they act. 19th June, you withdraw support. 20th June, you raise a promulgation under Section 92 of the J&K Constitution. Right? And you take all power to yourself and you dissolve the bloody assembly. Compare this to Maharashtra. He refuses to take a floor test. Correct? So Eknath Shinde suddenly pops up and says, no, I have the numbers. Speaker says, okay, you do the floor test. Every other state this happens, but not in J&K wasn't allowed to do this. I'm just pointing this out because that's the colorable bit here. Right? Now, on 21st of November 2018, now remember this, under Section 92, on 20th of December 2018, that proclamation under Section 92 becomes inoperative. Governor can no longer be in power of, can no longer hold the power of the state government. But on 21st November 2018, prior to the expiry of the 6-month period, Legislative Assembly was dissolved under 53(2) of the J&K Constitution. So, हमारे गवर्नर साहब ने 5 महीने के लिए लेजिस्लेटिव असेंबली वहां पे रखी हुई थी, लेकिन पावर्स उनकी सारी थी और उनको फ्लोर टेस्ट भी नहीं करने दिया. Right? Now this legislative assembly is dissolved, and I'm telling you, this is where your Abdullahs erred. This is the set of steps that they needed to challenge straight away in the Supreme Court.
I know exactly what you're talking about.
They didn't see what was coming, right? But be that as it may,
गेम कर डाली उनकी.
और वो समझ नहीं पाए क्या वो. So on 21st of November 2018, the Legislative Assembly is dissolved. On 28th of November 2018, Governor, this is where it gets really funny. Governor submits a report to the president. Now, I'm going to, if you can, before I read this bit, please take up Article 356.
Okay. Okay, I'll put it up in the let me try to open it because there's so many articles that I had opened that okay, I'll pull up Article 356 now. Hmm. I can imagine all the live viewers laughing right now as they're listening to you because now even they are getting कि government ने game कैसे बजाई इनकी. Okay, it's up on the screen.
Now, this is very
356.
important. When you go up a little bit more, you'll see the heading of the article. Yeah. Now, this is very, very important. There is a precondition already outlined in the topic of the article for the exercise of power under that article. Provision in case of failure of constitutional machinery in states. Right? So, failure of
Mm-hmm.
constitutional machinery being a precept, being an imperative.
Yeah.
Now, all of us growing up, having watched Indian politics, have talked about how Indira Gandhi weaponized this article.
Oh, absolutely.
She used to dismiss opposition state governments for fun. Right? The Modi government has lost on two occasions when it acted under 356. It has lost before the High Courts on two occasions when it's acted under 356. The states are becoming more and more. The Supreme Court is becoming more and more, is becoming much stricter on 356. Right? But 356 requires that if the president, and now the next words are very important, on receipt of a report from the governor of a state or otherwise, right? So you can form your opinion based on your own knowledge, but you can form it based on the governor's report. Is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the president may, by proclamation, and this now becomes vital, assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by the governor or any body or authority in the state other than the legislature of the state. So what happens? The president becomes the executive, right? Declare the power of the legislature of the state shall be exercisable by or under the authority of parliament, which means parliament becomes the legislature.
Absolutely.
Right? Make such incidental and consequential provisions as appear to the president to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operation of any parts of this constitution relating to any body or authority in the state, provided that nothing in this clause shall authorize the president to assume to himself any of the powers vested in or exercisable by a high court, or to suspend in whole or in part the operation of any provision of the constitution relating to high courts. In other words, judicial review you can't get rid of.
Hmm.
Right? Now that is very important. The 356.1 is very important. I want you to take a look at 356.5 as well.
Hmm. Here, I'll highlight 356.5.
Now, before actually we go there, uh, let's go to 356.3.
Okay, let's go to 3.
Every proclamation under this article shall be laid before each house of parliament and shall, except where it is a proclamation revoking a previous proclamation, cease to operate at the expiry of 2 months unless before the expiration of that period it has been approved by resolutions of both houses of parliament. Right? So parliament has to approve this. You can't act like the president and just do what you want to do. You have to place it before parliament. Parliament has to approve it. Provided that if any such proclamation, not being a proclamation revoking a previous proclamation, is issued at a time when the House of the People is dissolved or the dissolution of the House of the People takes place during the period of 2 months referred to, and if a resolution approving the proclamation has not been passed by the Council of States, but no resolution with respect to the proclamation is passed by the House of People before the expiration of that period, the proclamation will cease to operate at the expiration of 30 days. So if you, the long and short of this is, if by circumstances you are in such a position that you can't get these valid what do you call approvals from parliament, from both houses of parliament, sorry, that doesn't mean that you survive in limine and forever and ever. You fail. Tough luck. Now come to 4. A proclamation so approved shall, unless revoked, cease to operate on the expiration of a period of 6 months from the date of issue of the proclamation. Correct? So I told you
Hmm.
Section 92 also had a 6 month provision. That's Section 92 of the J&K Constitution. Had a 6 month provision. That power was exercised by the governor on the 20th of June 2018. Correct? Now, what does the
Mm-hmm.
governor do? Right? And this will create some very interesting interpretative questions that will become arguments by the petitioners. So the governor on the 21st of November 2018, sorry, on the 28th of November 2018, submits a report to the president. If you can go back to clause 1, that's the report he submits.
This.
That first line. On a receipt from of a report from the governor. Right? So on 28 November 2018, governor submits a report to the president for excessive powers under Article 356 of the Constitution. This is, remember this, the 6 month period under Section 92 of J&K Constitution is about to end. And I don't think they have a renewal procedure there. So what do we decide to do? We decide, chalo yaar, we'll grandfather this into the Indian Constitution.
Hmm.
So one of the questions that arises is, could 356 power be used against 370 when 370 opens with that, what I convert to you, the non-obstante, notwithstanding anything contained in this Constitution.
Hmm.
Right? So on the 20th of June, that 6 month period under Section 92 of the J&K Constitution is about to expire. So with the same alacrity that we have seen throughout in this reading of dates, on the 19th of December, sorry, on the 20th of December, it was about to expire. On the 19th of December, the president's rule is promulgated in J&K.
Hmm.
But now let's be clear, that first 6 month period was under Section 92 of the J&K Constitution. But
Hmm.
now you have another 6 month period that is now under 356 of the Indian Constitution.
Indian Constitution.
So the question is, does it operate like this in the context of J&K? कि कभी आप J&K Constitution के under चले गए. And then when you needed to exercise the power under the Constitution of India, you come to the Constitution of India.
Hmm.
And this is not a minor power. We are talking about a power that takes away democracy effectively, that takes away the elected government and the elected legislature effectively. You can remove 356 now. I don't need 356 anymore.
Okay.
Right? So, like 356 said, state government assumes the functions are assumed by the president, and eventually the president ordains through him the governor. Right? So the governor is the embodiment of the president in the state. 356
Hmm.
says president takes the power of the state government. Governor says I'm giving it to the president says I'm giving it to the governor. So one of the issues that will happen is governor forms a consent on behalf of the state government and gives it to the president, but the president and the governor are the same,
Yeah.
which effectively means the president formed his own consent and gave it to himself.
Boys played well.
In constitutional terms, it's a little absurd, because what does that mean? It means the checks and balances have gone.
Hmm.
Right? Constitutional power is all about identifying checks and balances and separations. So amusing though it may sound, it's a very serious problem constitutionally. Then state legislature's powers are assumed by parliament. Provisos to Article 3 are suspended. This allows for altering of boundaries and states. Okay? This
Obviously.
is what it allows for. This is where your reorganization comes from.
Yeah. Yeah.
Anyway, on the 28th of December, Lok Sabha accepts the proclamation, because I had shown to you in 356 that both houses of parliament have to accept the proclamation within a 2 month period. So before even 10 days have passed, Lok Sabha accepts it. On 3rd of January 2019, Rajya Sabha accepts it. Now, governor to exercise power of the president subject to superintendent's direction and control. Now, on the now 6 months pass again. 28th of June 2019. So let's be clear. 3rd January 2019 is when Rajya Sabha accepts it. Correct? So your 6 month period of reckoning in 356, that is the validity period of this proclamation under 356, starts on the 3rd of January. So before its expiry on the 28th of June 2019, Lok Sabha extends president's rule. On 3rd of July 2019, Rajya Sabha extends president's rule. 6 months under Article 356(4) start reckoning again from this date. And what I didn't show you on 356 was you can never have an unending power of this sort, or unending situation of this sort. This can last for a maximum period of 3 years. Right? So you do 6 months, then you add on 6 months. Then if Lok Sabha and Rajya Sabha agree, you can add on another 6 months, eventually totaling to a maximum of 3 years. At the end of 3 years, you must hold elections. So after Lok Sabha extends on Rajya Sabha extends on 3rd July, the game starts on the 5th of August 2019. Right? Now, I know people will remember, I hope people remember, from that 3rd July onwards, there was a lot of gossip going around and a lot of news media going around that they're starting to mobilize big time in JMK. Big time in JMK. Not mobilizing like they've never mobilized before. And the rumors were, what is about to happen? Is there something major happening warlike with Pakistan? But there were enough rumors to say 370 is going. Right? And those people like me who could never believe that such a great day would come were cynical about it. Like 370 to kabhi nahi ja sakta. But that's what happened. On the 5th of August 2019, Constitutional Order number 272, application to JNK, is passed. And what does this Constitutional Order do? All provisions of the Constitution of India to apply, superseding all preceding constitutional orders. Right? See, preceding constitutional orders applied only bits and pieces, piecemeal parts of the Constitution. Now we're saying the entire Constitution applies. And can you pull up Article 367?
Sure, I'll do that. Give me a moment. 367 or 357? You had typed 357.
Let's go to 67.
Okay, then I'll have to.
Sorry, I forgot to put that in the list.
Yeah, you did not give me that. Wait, I'm opening it. Just give me a moment. Article 367 of the Indian Constitution, right? Okay. Where is it? Let's look it up. Okay, Article 367. Put it up now. There you go.
Very simple. It's an interpretation clause. Right? It's not a substantive power. It's not a substantive rule. It doesn't give power to anyone. It doesn't take away power for anything. Just a simple interpretation rule. Right? And you will see in the 367 that you have pulled up, there are only 3 clauses.
Yeah.
So, what happens with CO 272 is clause number 4 is added. If you want, you can get this very quickly. Please pull up Constitutional Order 272. Just type in Constitutional Order 272 PDF. In fact, let me see if I have it open. No, I don't have it open.
272, right?
Yeah. Constitutional Order 272 PDF.
Okay. The Constitutional Order 272 document. Yep. PDF is opening. Just give me a moment.
Man, Adobe has this liquid mode. Now it slowed everybody down in the opening of documents. On the phone, it's so irritating. I can't begin to tell you.
Oh, yeah. But on the PC, it's not that bad. It's not that bad on the PC. So it can be done. There you go. Notification.
Right? Now come to the second one. All provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So these are the only exceptions that will apply. So 367(4) applies only to JNK. To Article 367, there shall be added the following clause, namely Clause 4. I showed you there was only Clause 3 earlier, now Clause 4 comes in. For the purpose of this constitution as it applies in relation to the state of Jammu and Kashmir, a reference to this constitution or to the provisions thereof shall be construed as references to the constitution or the provisions thereof as applied in relation to the said state. It sounds very prosaic and very dull, but it is important because what this means is the whole constitution applies to you now.
Yeah. Basically,
Right?
this is game over.
Yeah, references to the person for the time being recognized by the president on the recommendation of the Legislative Assembly of the state as the Sadr Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir. In other words,
Game
Kushal, have you
over.
disappeared?
No,
Sorry.
no, I'm here.
Game
Yeah.
over nahi hai. What it means is the Sadr Riyasat is now the governor.
Yeah, that's what, na? So it's
References
game
to the
over.
government of the said state shall be construed as including references to the governor of Jammu and Kashmir acting on the advice of his council of ministers. And in D, in proviso to clause 3 of Article 370 of this constitution, this is the most important change and the most contested change. The expression constituent assembly of the state referred to in clause 2 shall be read as legislative assembly of the state.
Just can't
Right?
stop laughing. This is too funny.
So this is what they do. This is on the 5th of August. Immediately on the 5th of August, Rajya Sabha, now Rajya Sabha is acting like the Legislative Assembly of J&K, not as Rajya Sabha of the Union of India, but acting under 356 as the Legislative Assembly of the state. So it gives its recommendation to the president. All clauses of Article 370 shall be inoperative, save and except clause 1, which stood substituted. That substitution had also happened. That's CO 273.
Mm-hmm.
Rajya Sabha first, and then on the same day, and Lok Sabha then accepts J&K reorganization bill under the proviso to Article 3. That is where you become a union territory with a
Mm.
legislative assembly, and Ladakh becomes a union territory without a
So, Article
legislative
3
assembly.
is formation of new states and alteration of areas, boundaries,
If
or
you want to
names of
pull that up, we
existing.
can do that as well because it's a good place to start to learn this stuff.
Hmm. This is your Article 3.
Parliament may, by law, form a new state by separation of territory from any state, or by uniting two or more states, or parts of states, or by uniting any territory or to a part of any state. This is how your entire linguistic reorganization of states was effected in 1956 and 57. This is how those huge presidencies, Madras presidency, etc., were carved out into different states. Madras presidency was massive. It used to extend. It used to be Kerala, Tamil Nadu, Andhra, parts of Odisha, going all the way up to the Calcutta side.
Mm-hmm.
Right? So that's the same thing you read. Now, Parliament may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. So I can today take a part of Jharkhand and make it into Bihar, or take a part of Bihar and make it into Jharkhand. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state. We can change Maharashtra into Kushalabad if you'd want.
I would prefer that.
Provided that no bill for the purpose shall be introduced in either House of Parliament except on the recommendation of the President, and unless where the proposal contained in the bill affects the area, boundaries, or name of any of the states, the bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified, in reference to which such other period as the President may allow, and the period so specified or allowed has expired. In other words, you're only taking the opinion of that state legislature.
Mm-hmm.
They don't get to pass or reject. You're only taking
Yeah.
their opinion. President is then empowered. I've taken the opinion, they're opposed to this. So really, maybe I shouldn't do it. That power is left in the president and in the union effectively. Right? So what I was just reading to you is the Rajya Sabha doing exactly this.
Yeah.
That you asked us about this alteration, we accept the alteration. the rest of this is not material. I just wanted to show this just so that people have an idea what I'm talking about, right?
Got it. What is
Now,
fascinating is I repeat again, everybody remember when we said in the start the role of the president and what is the legislature. Now you will understand what the government was
but the
doing.
president under Indian constitutional structure is the prime minister and the council of ministers.
Exactly.
The stamp and the thappa is of the president, but the actions are of
President
the union government, right?
on Union.
Uh, Now, Lok Sabha recommends to President on the 6th of August that all clauses of Article 370 shall be inoperative. So now what Rajya Sabha had done on the 5th, Lok Sabha does on the 6th. And Lok Sabha also passes the J&K Reorganization Act. Now you can pull up if you'd like. Actually, if you can just, I'll share screen and I'll show it to you.
Which one do you want?
I'll do it. Sure. Right, can you see this?
Yeah, it's not come up till now. And my end. Did you choose present screen or what? What did you do? Oh yeah, now it's come. Now it's come. Now it's come. Come.
Right? Have you got it
Yeah.
up? All right.
Yep.
Now, opening words. In exercise of the powers conferred by Clause 3 of Article 370, read with Clause 1 of Article 370, the President, on the recommendation of Parliament, is pleased to declare that as from the 6th of August 2019, all clauses of the said Article 370 shall cease to be operative. These are very important words, Kushal. 370 subclause 3 use the word Constituent Assembly. The last GO says what is Constituent Assembly becomes Legislative Assembly. Correct? But because of your proclamation under 356, what is Legislative Assembly becomes Parliament.
Parliament.
Right?
That's so
And so
funny.
therefore, when the president acts, he's acting not as the president of India, he's acting
But the
as
parliament.
effectively the state government.
Yeah, he's the legislature. मैं वही तो बोल रहा हूँ वो जो
No, the state government. And on the
yeah
recommendation of parliament, meaning parliament is effectively the state legislature.
स्टेट गवर्नमेंट वो मैं
It's
बोला
the
ना वो जो
legislative
क्या
assembly.
पिक्चर थी वो जो चाचा है वो भतीजा है वो भतीजा वो चाचा है चाचा भतीजा एक ही है.
Effectively, I'll summarize this in a second. Is pleased to declare that from the 6th August 2019, all clauses of the said Article 370 shall cease to be operative. All provisions of this constitution, as amended from time to time without any modifications or exceptions, shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary contained in Article 152 or Article 308 or any other article of this constitution or in any other provision of the Constitution of Jammu and Kashmir or any law, document, judgment, ordinance, order, bylaw, rule, regulation, blah, blah, in force in the territory of India or any other instrument, treaty, or agreement as envisaged under Article 360 or otherwise. Everything is gone. Right? Now, please see, they override the Constitution of Jammu and Kashmir as well. Right? I'll show that here. Or any other provision of the Constitution of Jammu and Kashmir. So they override that. And any other instrument, treaty, or agreement. So goodbye, instrument of accession.
Exactly.
Right? I'm going to now stop the screen. I think people have got the idea.
Boss, this was designed by legal geniuses.
No, so just in summary, 370 says you first need the consent of the state government and then you need the approval of the Constituent Assembly. So what do? They use 356 to make state government into governor effectively or president effectively and legislative assembly into parliament.
Exactly.
Right? Then they go into 367, they insert an article on interpretation and they make constituent assembly the same as legislative assembly.
Same kar diya.
Right? That means now all powers are being exercised by two bodies. One, the president, and two, the parliament. And they play their little badminton match and this is all done.
Yeah. And it is all legal.
Well, now it's legal. Court is upheld, but we're only in the process of examining all of this. Abhi to bahut arguments aayenge.
Long live Justice Chandrachud.
Right. Now, just for the sake of fullness, Lok Sabha passes the J&K Reorganization Act on the 6th of August. This what I just read to you, Constitution Order 273, uh, is passed on 6/8 by Lok Sabha as well. MHA issues a standing order 2889 sub bracket E under section 2A of the J&K Reorganization Act, saying this will take effect from 31st October 2019, because they needed that about 40-45 days to do everything, right? To set your machinery up now.
Mm-hmm.
Now I'm going to come to the broad submissions of the petition. I mean, we've already gone through an hour. I'm telling you, we could even do 3 parts on this. I've just given the background of what was done and what 370 was. I could do an entire 1.5 to 2 hours just explaining to you the arguments of the petitioners and then the judgment. But I don't think you are in the mood for 3 parts of this particular podcast.
दो part.
2 is enough, right? So for 2, then I need, this is going to be a long one, because I need to then go through the petitioners' arguments now.
कर आराम से कर यार.
Now, on the 20th of June 20, so the petitioner's submissions first is that first exercise of power by Shri Satyapal Malik, who since then has become extremely upset with the
एकदम
government
rogue agent.
and has been saying that the Jat community will avenge his dishonor. Who was the pilot of the entire operation for a year.
Most-
He held the fort, boss. Don't ever underplay his role in all of
Great.
this. He held the fort
Great.
for a year before
Great
you
man.
acted. Right? So he on 20th June, you'll recall, I had told you on 19 June, Mehbooba Mufti 2018, Mehbooba Mufti resigns. Our governor sir says, forget about any other combinations of coalition governments. मेरे हिसाब से तो कुछ बच ही नहीं सकता. मैं ले रहा हूँ सरकार की power. I'm taking all of the governmental power, right? I'm not commenting on the validity or invalidity of all of this. I'm just explaining what has happened and the petitioner's
Yeah,
argument.
it's a matter of fact
Then
how
the
things
opinions
went.
will come as the arguments are set out, because I just want to set out the petitioner's arguments. And a lot of what I want to say will come in the second part, actually. Right? So they say that this proclamation under Section 92, whereby the governors are entrusted with the power of the state government, since there was no break. This is a colorable exercise. This is an invalid exercise. This is a void exercise. It is a void exercise because the precondition in Section 92 of the J&K Constitution is there should be a breakdown of constitutional machinery. It was a purely political act designed for the ultimate abrogation of Article 370. Other parties had indicated a willingness to form a coalition government, which opportunity was not afforded to them. And in fact, one of the submissions made is that in the intervening period between the dissolution on the 19th and the adoption under Section 92 of the J&K Act on the 20th, a fax was sent by these parties saying we are willing to form the government together, which he refused to recognize, right? But just to give a little bit of context, people will remember this is 2018, but the summer of 2016 and a bit of 2017 had been terrible in J&K. 17 not so much, because the summer of 2016 is the Burhan Wani death. The Burhan Wani killing. And the quantum mistake, and this is where I think relationships really broke down. Mehbooba Mufti was crystal clear that Burhan Wani has to get a public janaza. That janaza was a hero's welcome. And we are now realizing 4 years after the abrogation of Article 370 that these janazas, being such fated events, was more a compulsion because of where the power lay, where the gun lay. Right? But that was the one in which, for example, if you remember, we were using rubber pellets to disperse crowds. Children were being blinded by rubber pellets. There was a lot of hue and cry the world over. So when this argument is made that there is no breakdown of constitutional machinery, you have to bear this in mind, that this was a context. Now in 2016 November, demonetization happens. For whatever reason, 5 तारीख मोदी साहब को बहुत पसंद है, so 5th November 2016
उनके एस्ट्रोलॉजर ने उनको बोला होगा 5 तारीख को सब करने का.
So 2017 summer is a quieter summer in J&K, but still problematic. And there are still bad events occurring. In fact, if you remember, Pathankot happens at this time, and the events that lead up eventually to Balakot happen at this time before the election in 2019. So whether or not there is a breakdown of constitutional machinery, that is a question that perhaps the judgment doesn't record in the kind of detail that was necessary. But they needed to make a more detailed argument on how there was no breakdown of constitutional machinery. That in fact, if you have such events in certain states, it should be the state government that has the power to deal with it, first and foremost. Be that as it may, this is their argument. No breakdown. So your first taking of power under Section 92 of under the J&K Constitution itself is void. Right? Now, Section 92, and this is the question I had raised in between. Section 92 imposes an outer limit of 6 months. There is no renewal procedure under Section 92 of the J&K Constitution. Thereafter, tacking on the provisions of Article 356, which allow a repeated 6-month extension for a total period of 3 years, is a fraud on the J&K Constitution. In other words, the Constitution of India is used to perpetrate a constitutional fraud under the provisions of J&K Constitution. These are all political decisions not borne out from constitutional considerations. Constitutional considerations are actually always a little bit distinct from political considerations, because constitutional considerations take away political emotion and say what can be decision-making criteria and what cannot be decision-making criteria. That's the purpose. Right? And so they say that these decision-making criteria were no longer satisfied. But there is a larger problem. You can't jump from one constitution to the other constitution. For which reason, one of the issues the court eventually decides is what is the status of J&K sovereignty. Because if in fact J&K was sovereign, as I had read in the lead up to article, and that's why I'd given the background, where Sheikh Abdullah himself was saying, effectively we are sovereign for ourselves, but just these three things are gone. Right? That is what dissipates. That's the basis of the argument here. That if we are sovereign, then you can't, that if my provision says only 6 months, you can't suddenly introduce the 356 from the Constitution of India. Right? Especially because 370 already has a non-obstante. You can't suddenly impose from 356 but the problem was this. Throughout the 90s, 356 had been imposed.
So there was a precedent for that.
Well, there is an executive action precedent, but there is no judgment that upheld the power.
And also all of this change was also justified by what was that reservation related thing that was set
that
up
will
by
come
the
later. See, those I'm not looking at those, because those are ancillary arguments, as I call them. All right. So there is the fundamental rights of that are guaranteed to other citizens don't immediately apply in J&K. Fine. But first we're looking at constitutional mechanisms. Right? Then we'll get to this. And yes, of course, it's an important point, but it is not a point that can supplant the constitutional mechanism. So again, just to reiterate, here the problem becomes which constitution prevails. If J&K Constitution says only 6 months, can you suddenly bring in a provision from the Indian Constitution that says 3 years tak ja sakta? So there's a clear contradiction between the J&K Constitution and the Indian Constitution. And on the 1912-2018 proclamation by the president is void ab initio. The 1912-2018 proclamation by the president was the one in which he imposed 356 on J&K, based on the governor's report, which was provided to him on the 23rd of November 2018. Okay, and it is void because the governor's report by which Parliament accepted the proclamation was not placed before Parliament. Apparently, they're raising a procedural argument here. This is something I'm not aware of because I didn't sort of hunt down what happened on that day in Parliament. But their claim is both houses passed the motion without debate and without the governor's report. Right? Basis of breakdown of constitutional machinery is therefore not clear. Which, in other words, if Parliament is not even looking at the governor's report, how can Parliament make up its mind that in fact there was a breakdown of constitutional machinery?
That's what they're saying.
That's what they're saying. Now, that breakdown of constitutional machinery is a common requirement of both Section 92 of the J&K Constitution and of Article 356 of the Constitution.
Yeah, which we read.
Right. So how are you making up your mind if you don't even have the report? So this is effectively a unilateral exercise of 356 powers by the party in power, which is a result on the federal character of the Constitution, can lead to abrogation of several other special interests as carved out in the Constitution. This was their bogey, saying like, oh, so now you can go do this in the Northeast also. At any point in time, central government straight away, there's nothing, we're going to do nothing in the Northeast. Right? One battle at a time. But theoretically, they're correct. That if you can unilaterally start using 356 like this, and by the way, let's be clear, this kind of unilateral brazen use of 356, today you say it is for a positive purpose. That is what a lot of us believe, right? 370, and
Hmm.
eventually over time it's proved to be that. Even in a short period of 4 years, you've had trenchant critics of 370 turn to the side and say, yeah, this is the best thing you could have done,
Yeah.
right?
Shaila Rashid and Shah Faisal being the first ones.
Big prime examples, but that does not mean that it is not a extremely forceful use of 356.
Yeah, but this was
That's
a
what they call.
this was a special state and a
Everything
special
can't be
case.
everything can't be waved away as special, Kushal. Eventually, you come to a point where precedents start getting set, and when the boot is on the other foot, it will look worse. Anyway, now they say that actions taken while the 356 proclamation was in force are void. What were these actions? These actions were president acting as state government and parliament
Hmm.
acting as state legislative assembly. So they say once the legislative assembly is dissolved, because he specifically dissolved it,
Hmm.
right? No occasion for president to exercise power under Article 356. So if Article 356 proclamation itself has no basis in law, all other actions taken thereunder are also void ab initio. In other words, for 356 to apply, once you have dissolved the legislative assembly itself, your next step should be elections.
Hmm.
Purpose of Article 356 is in fact to restore governance in the state as soon as possible, not to make changes of this sort. Purpose of 356 is you have identified some breakdown in constitutional machinery. You will rectify that problem because you perhaps have more resources and more power as the center. Once that rectification occurs, you must restore back the old constitutional norm, the natural constitutional norm, that the state government will have its own the state government will have its own elected government. The state will have its own elected government, right?
Hmm.
Now, Article 357(2) stipulates that laws made by president. I'd asked you for 357 as well, right? This is very interesting. I want this pulled up.
Hmm. I'll
This
pull
is a
it up.
very core central argument to what is going on.
There you go. Exercise of legislative powers under proclamation issued under Article 356.
Yeah, yeah. If you can come to two, any law made in exercise of the power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or the president or such other authority would not, but for the issue of a proclamation under Article 356, have been competent to make, shall after the proclamation has ceased to operate continue in force until altered or repealed or amended by a competent legislature or other authority. In other words, the argument is that because this repeal can happen, really speaking, you make laws of a temporary nature for a temporary period of time because of the breakdown of constitutional machinery, but there is no idea, even under the 356 mechanism, of an absolute usurpation of the state's powers.
Hmm.
So you make these laws, no problem, for that period of time. But the moment the state government is restored, it can say, "Ye sab hata.
Hmm.
We're deleting everything." Right? Which means what? Which means the inherent intent of these provisions is that parliament acting as the state legislative assembly in a 356 proclamation environment cannot make irreversible changes. This allows for a continued for the form of the constitution to be maintained. That is a direct quote from B.R. Ambedkar, right? Just to simplify, you cannot make irreversible changes because the power always remains with the state. You just have a special circumstance in which you are governing for a while. The state will now take over and go back to making its rules as it was. So you can't be making irreversible changes. Is the essence that they derive from this article, not that the article
Hmm.
says you can't be making irreversible changes,
Hmm.
right? Now, can you pull up Article 250? I had asked you for that as well.
Sure. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation.
That's 356.
No, that's 250. The
No, no.
Sweeton.
356 is a proclamation of emergency,
Yeah, yeah, okay, I got it.
right? Now, subclause 2.
Hmm.
A law made by Parliament, which Parliament would not, but for the issue of proclamation of emergency, have been competent to make. In other words, at the time at which Parliament effectively becomes a state legislative assembly, right? It is actually exercising the legislative powers of the state legislative assembly. But those powers are not exercisable by the Parliament as Parliament,
Hmm.
right? So, if it makes laws that otherwise would fall under the state legislative assembly's ambit, to the extent of the incompetency cease to have effect on the expiration of a period of 6 months after the proclamation has ceased to operate, except as respects things done or omitted to be done before the expiration of the said period. Very important clause. The end. I'm going to. Can you highlight the middle bit first? To the extent of the incompetency.
To the extent of the incompetency, I'll just highlight the whole thing if you want.
No, 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 no. I want to go clause by clause. The word incompetency is not used in the context in which we have Twitter battles and Twitter fights.
Hmm.
Incompetency is a legislative term of art, it's a constitutional term. You
Okay.
are competent to make a law or not competent to make a law. Parliament is not competent to make a law in the legislative entries in list 2 of that 7th schedule that I'd shown to you earlier.
Hmm.
If Parliament makes a law on those issues, that law is void. But because 356 is in force, Parliament is at that moment in time acting as a state legislative assembly. Correct? And it is therefore passing laws under that list too. Or in the case of
Hmm.
JNK, under the power, under the legislative heads that the state of JNK had the power to pass laws under. The moment that proclamation ends, you are now back to being parliament. In other words, you were a body that never had the power to exercise that,
Hmm.
pass that law. So automatically, the extent to which you have passed laws uh, which are beyond the competent of parliament qua parliament, right? Parliament as parliament. Those laws immediately cease to operate at the period of at the expiry of 6 months. But actions you have taken under it, now you can highlight the last bit, except as respect of things done. No, no. Okay. Cease to have effect, except as respects things done or omitted to be done before the expiration of the said period. So there are things that you have done, those remain stable. You can't reverse everything, right? So the argument then becomes that Article 250 subclause 2 states that laws made by Parliament during the existence of 356 shall cease to have effect to the extent of the incompetency. Having taken away this ability of the state in question, the measures adopted are void since they could not be of the permanent nature that they profess to be. I mean, I'm rephrasing that argument, but what have you done here? Parliament 356's entire concept is you will reinstate the government, and any laws that you have passed. First, I've shown you 357,
Hmm.
where that particular state legislative authority, when it comes back, has the right to either uphold or reject or repeal altogether whatever Parliament may have done in that interim period. And second, that even if it doesn't, if a part of if a law is passed by Parliament during that proclamation period, which otherwise Parliament would not have had the power to do, then that is automatically gone. So the constitutional structure as per the petitioners is that the state legislative authority has to be recreated. You must bring it back. And it will decide whether the actions that you have committed during that period are in fact valid actions or not.
Hmm.
By acting in the way in which you have, by creating this permanent change, you have in fact withdrawn that ability as well.
Hmm.
Now, transfer of power of the government and legislative assembly to president and parliament respectively under 356(1) do not include the transfer of constituent power. Constituent power cannot be transferred unless the J&K constitution specifically provides for it. Hence, the president cannot give concurrence under Article 371D, nor can Parliament recommend a presidential notification under Article 370, subclause 3. In other words, when you are exercising, and these are called as functions or
Hmm.
powers of that legislative assembly or of the government, those are to be acts in the nature of the management of the day-to-day operation of the state, right? Constituent power means the ability to create a constitutional change. Under 356, you cannot take to yourself powers that allow you to completely change the JNK constitution. It's a very compelling argument. It's a because the nature of constituent power and of legislative power is very different. Very, very different.
समझ गया.
Now, then they make one argument that president's ordinance making power cannot be treated as constitutional equivalent of ordinary legislative power. Same for president's executive power via state executive. In other words, when you're acting under 356, you cannot actually presume that you are in fact the authority on behalf of whom you're acting. You're only acting for a limited purpose in a limited manner. Article 75 and 164 of the Constitution of India stipulate that the Council of Ministers is responsible to the legislature. That's basic
Hmm.
checks and balances, right? Now, the state's legislative, non-legislative functions such as questions and debates cannot be exercised by Parliament during President's rule, right? So, you actually, therefore, have not had a debate as contemplated under 370 subclause 3 or 370
Hmm.
subclause 1 to be able to give a consent. Because this is not a minor power being exercised, it's a significant constituent power that's being exercised. The will of the people finds no expression in the purported concurrence of the state government through the governor. The constitutional orders are unconstitutional for want of public will and public reason. You have, let's be crystal clear, actually acted to circumvent and subvert completely the will of the people as you understood it. You didn't want to engage with the will of the people. Otherwise, when you were in fact in government at that time as a coalition partner, you would have done it through the state government and through the state
Hmm.
legislative assembly. But you couldn't, and you therefore to subvert that, you took this process altogether.
Hmm.
Then they have certain certain arguments on the interpretation of Article 370. Article 370, and we can go back to it when we're doing the whole judgment again, but it sets up three modes of cooperation between the union and the state government. Mere consultation as required under Article 370, subclause 1, subclause B, where then there is a category where consent of the state government is required under 370, subclause 1, subclause B, subclause 2, and second, provided to Article 370, subclause 1, subclause B, and of course, the last, which is where recommendation of the Constituent Assembly is required under Article 370, subclause 3. So you can think
Hmm.
of them as rising requirements. The first is the easiest, where it's merely consultative. The second is where the state government's consent is required, and the third is where the Constituent Assembly's consent is required.
Hmm.
Article 370 represents asymmetric federalism, autonomy, and consent.
Asymmetric federalism. मतलब what a word salad. I have to appreciate it.
No, it's not a word salad. This is what happens in consociated constitutions all over the world. Asymmetric federalism means there are differential rights vested in certain federal subunits. You will find that in the context of the Northeast as well. Certain provisions don't apply to the Northeast. Personal taxes don't apply to the Northeast. That's asymmetric federalism. Certain powers are given to certain states that other states do not have, because these are deemed necessary for the creation and the subsistence of the union. And that is what Article 370 in the context of J&K represented. That's the argument.
Hmm.
And that if you wanted to then move away from this, you had to first deal with the fact that 370 embodied a certain autonomy for J&K. And lastly, that if you had to move away, then you needed their consent. And this is a very natural argument. This was supposed to come at some point in time, that Article 370 is effectively contractual in nature. It is effectively a contract between the Union of India and the state of J&K.
That's their claim.
they're presenting it that way. That's what they're saying. Article 3.
Which was
I'm
rejected by
only
the
covering the
courts.
petitioner's arguments today.
Yeah,
I
I
want
know,
to cover
which
the
was
full
rejected
detail.
by the courts.
Yeah, the Constituent Assembly of India was established, which was empowered to determine the constitutional relationship between India. No, sorry, the Constituent Assembly of J&K was established. And when it ends, it determines the entirety of the constitutional relationship between J&K and India. That's a power that you gave to the state of J&K, which you gave to no other state. And when that Constituent Assembly ends, it does not say dissolve 370 and apply the whole of the Indian Constitution to us. It says, no, we are taking our own Constitution. Now, in the absence, therefore, of the Constituent Assembly, no further change can occur to Article 370. Article 370 can only be modified under Article 370, subclause 3, for which you require the consent of the Constituent Assembly of J&K. The Constituent Assembly of J&K no longer exists. Therefore, Article 370, subclause 3 cannot be changed anymore. By its own terms, despite it being termed as a temporary provision, by its own terms, it in fact becomes a permanent provision. And what is the argument on the other side? Look, when it was necessary, you started to read the Sadr Riyasat as a governor. And we have now put in an interpretation clause saying because Constituent Assembly doesn't exist, you can't have an impossibility. So you can read that as a legislative assembly. Different matter that legislative assembly effectively becomes parliament in this case. And Sadr Riyasat becomes, instead of state government, becomes the governor slash president. But this argument, which I just read out, that Article 3, that in the absence of the Constituent Assembly, Article 370 acquires the permanence. This is an argument repeatedly observed in court and made in court by Justice R.F. Nariman. He's a big proponent of this argument that you cannot damage the constitutional language anymore. Right? Unlike other states, the constituent power remained with the people of J&K through the state's constituent assembly, subject to Article 1 of the Constitution. Like I pointed out, you set up a constituent assembly for J&K, and therefore that is a peculiar power given to J&K. And 2, that residual entry in entry 97 in list 1. You've never extended even that to J&K. So you yourself, by your actions, by your constitutional framework, have always kept J&K separate and distinct. Now comes the issue of, but the counter argument is, you have put Article 370 in Part 21 of the Constitution, and Part 21 of the Constitution reads as temporary, transitional, and special provisions. And Article 370 itself reads as temporary provisions with respect to the state of J&K. Right? So the question became, if it's temporary, then why can't it go? So their answer to this is, there is no merger agreement with India. It was temporary pending a merger agreement, but you never entered into a merger agreement with India. And the effect of not having a merger agreement is that the state retains its residual sovereignty. Article 370 is the constitutional mechanism by which this residual sovereignty is recognized. The Indian Constituent Assembly had assumed that the J&K Constituent Assembly would, on establishment, recommend the abrogation of 370, which it did not. That was the expectation. In 57, you would turn around and say, now we don't need 370, we're adopting your constitution. But the Constituent Assembly in J&K does the opposite thing. It says we're taking our own constitution and we're keeping 370. Specifically, the mechanism for Article 370, the abrogation was provided by 370 subclause 3 itself, and thus outside the purview of Article 368, which applies to all other provisions. Which means what? Which means that in relation to this specific article, which creates your relationship with the state of J&K, even your most peremptory article, which is the power of amendment of the Constitution, does not apply. You can apply it to everyone else and to everything else in the Constitution, but you cannot apply it to 370. If you could have applied it to 370, Kushal, all this drama was not needed. You have a brute majority in Parliament, you would have said we're amending 370, end of story. right? This is an indication again that you place J&K at a separate sovereignty. So the word temporary now has to be given a meaning. So they say the word temporary, in as much as the J&K Constituent Assembly was not in place at the time of its insertion in the Constitution of India, that is what the meaning of the word temporary. That it is temporary for J&K qua the establishment of a Constituent Assembly, because 370, the way it is drafted, itself contemplates that the Constituent Assembly is not in place as yet, but it will come into place. And it does not do so for any other state. So the temporary element is only that the Constituent Assembly will come together and make its decision. Once that decision is made, that's the permanent decision. The word temporary in the marginal note only implies that removal can be by way of the conditions mentioned therein and not without. In other words, you have 370 subclause 3, which places the temporary nature is okay, can be temporary if, like every other article in the Constitution, can be temporary, subject to basic structure. You can remove it all if you want, but you have to do it by the conditions given. And the condition given is Constituent Assembly has to say yes. So when the Constituent Assembly dissolves, that a power to exercise that ability goes away. Now, you'll recall I had read one of those earlier judgments in which I had said that one of the arguments was that
Which one? The
370.
50s one or the 70s one?
No, there was more than one. There was one in which, in fact, they had said that 370, that they had tried to say, in fact, the 70s one, you're correct in pointing that out, Sampath Kumar, where they had, in fact, tried to say that the Constituent Assembly having been formed, the Constitution having been framed in J&K, 370 now is nothing. It's dead. So there is no way mechanism by which Indian provisions can apply to J&K.
So these guys use that argument.
One of them did. To say your constitution now means nothing. This was argued by senior advocate Dinesh Dwivedi. State of J&K retained a part of sovereignty unlike any other state. The instrument of accession is the only descriptor of the relationship between the state and India. Since there is no merger agreement, the instrument of accession exceeds certain legislative matters to the union but retains residual sovereignty. I've been through this. The very existence of a Constituent Assembly and a separate constitution indicates sovereignty. Article 370 subclause 2 further underscores this. If a matter is to be brought within the power of the union by concurrence with the state government, and that has to be placed before the state Constituent Assembly. Right? This was that provision that said that if you have concurred on some things to go under the union parliament prior to the formation of the Constituent Assembly, because I remember I told you there is a time gap between the Indian Constitution, therefore Article 370 coming into force, and the J&K Constituent Assembly sitting, which happens 18 months later. So that provision had said that if during that time you have put into force certain provisions of the Indian Constitution by giving consent as the state government, then those things have to now be placed before the Constituent Assembly. And only if the Constituent Assembly accepts them will they be accepted. Therefore, the effect of doing that and the effect of Article 370 subclause 2 and the way you worded it is that you cannot say that the J&K Constitution is subordinate to the Indian Constitution. They are separate and independent documents.
We go back to that line by Shama Prasad Mukherjee. Ek desh mein
Independent and perpetual documents, right?
Yeah, basically.
Now they turn to CO 272. 272 is the one where I showed you they inserted 367.4. And where your Chacha Bhatija line, where they started changing everyone into everything.
That's the best part.
Just in the simplest sense, what they did was they took state government to mean governor, right? And the real progression there is Sadr Riyasat becomes state government becomes governor. Constituent Assembly becomes legislative assembly becomes parliament. So the eventual exercisers of power are governor and parliament. But power on behalf of J&K. The term Constituent Assembly, as used in Article 370 subclause 2, could not be subclause 2 and 3 could not be ordered to mean something else, because the nature of a body like the Constituent Assembly is a different body, right? So the Indian Constituent Assembly, the one that we often talk about, that gave us the Constitution, is inherently a different body from any other body, right? Different matter that in parliament, so what they could establish a constitution with a mere stroke of the pen. They didn't need anything other than a concurrence amongst themselves. But for the Indian government, Indian parliament to amend constitution, you need majority. Sometimes you need much more than a majority. Sometimes you need even the consent of the states. So inherently, the constituent power of a constituent assembly is greater than the constituent power of even a legislative assembly or of a parliament. Now, this is a very, to me, this is a very interesting and very compelling argument. I read 367 to you. 367 is an interpretation clause, right? What have you gone and said in 367? Your jhol is X will mean Y will mean Z. What you did in 367 was to say that the state government will mean the governor. The constituent assembly will mean the legislative assembly. Then you apply 356 and governor becomes governor, obviously. And the state legislative assembly becomes parliament. But what have you done effectively? By saying that we can alter interpretation under 367 subclause 4, you are effectively amending 370 subclause 3.
Mm-hmm.
Because you have
That was a
changed
cascading effect.
so you've effectively altered 370 subclause 3. This is the bit which I think is the weakest part of what the steps taken over. Because 370 subclause 3 in its own spirit says you can only, president may amend 370, but with the consent of the constituent assembly. Right? In other words, president doesn't need to act in any capacity other than his own capacity as president of India. And that's what we saw in that CO. President acting in his capacity, but parliament giving consent. Governor and parliament giving consent. So, what you could not do under 370 subclause 3, if you had to do it ordinarily, what would you do? You would have the president pass a order saying constituent assembly should be amended to read state legislative assembly. Right? But for that to be valid, you now would have had to go back to the constituent assembly of J&K. But there is no constituent assembly of J&K. In other words, you could not have amended 370 subclause 3. And if you could not have amended it that way, you certainly cannot amend it by just making a change in the interpretation clause, because the interpretation clause is a non-substantive clause. It does not create powers and rights and remedies. But you have used it effectively to completely alter constituent power. Where constituent power sat and resided in the constituent assembly, you have altered that to suddenly mean legislative assembly by one switch in the interpretation clause. Now, this is a very interesting provision of the J&K constitution. So, part 12 of the J&K constitution, which is section 147, is the amendment to the constitution. And in their proviso, they say that no bill or amendment seeking to make any change in the provision of the Constitution of India as applicable in relation to the state shall be introduced or moved in either house of the state legislature. In other words, even if you are acting as the state legislature, which is parliament, is acting as the state legislative assembly, you can't be recommending a change into the Indian constitution. No such bill can be tabled even before the legislative assembly. So you have acted in a sense by accepting these constitutional orders even beyond the power of the state legislative assembly had it existed at that moment in time.
But I actually know this argument, how the government is going to be responding to this, but that's okay. That's
No,
for
I'm
part
sure
two.
we'll get to all of that. I'm just pointing them out now.
Yeah, but this is the easiest point to answer. I actually know how the government would deal with this, but again, like I said, that is for part 2.
I've already pointed out the non-obstante to you. The way they use the non-obstante. The way they use the non-obstante is to say that if 370 subclause 1 of the non-obstante, then you can't be exercising powers under 356. right? Unless 356 itself had a non-obstante, then you
Mm-hmm.
could be exercising powers under 370. Then one very simple argument which says that look, 370 subclause one's idea was that you would have portions of legislation, portions of the constitution applying to JNK. When you apply the constitution wholesale, there's actually no application of mind, because the
Mm-hmm.
application of mind had to relate to events and incidents in JNK which required the specific application of a provision.
Got it.
Right. The establishment of the state constituent assembly was a fulfillment of the promise that terms of accession under the IOA would be determined by the people of the state. That was your contractual agreement.
Mm.
That was embodied in the constituent assembly. That's why you can't alter it today. Uh, then that bit where I told you that under CO 272, the Constituent Order 272, the president is obtaining his own consent. Right? Effectively, the state government is giving consent to the
Yeah, but the
president to
president
act,
is the state government.
yeah, and where the president himself is the state government. And
Yeah.
that's a breakdown of the checks and balances within
So
the,
what they're saying is this was done where they became the judge, jury, executioner.
and in effect, therefore, you bypass the will of the people.
Yeah.
State government would have affected the will of the people, would have represented the will of the people.
Mm. Before people get nervous, try and understand what we're trying to do is explain what the petitioner had said. All the answers of how the courts dealt with these arguments will be in part 2, which will be on Tuesday.
Yeah, but I did want to do it this way
Mm.
because I wanted people to know that these arguments are not, they're very persuasive arguments. They're not ordinary arguments,
Hmm.
right? Like this is why it's such a fountainhead case. It looks at federalism in such a broad spectrum. These are not arguments that you can just brush aside. The status of the Constituent Assembly is a crucial argument. It's not a very simple argument to get passed.
Mm.
If it was something you could get passed, why did you frame 370 the
Okay.
way in which
Can
you
I
did?
ask you a few questions that the viewers have asked?
We'll get to that. I just have the last few, like it's a little, I just
Okay.
have about 5 minutes to talk and then we can do the
Okay.
questions.
Okay. Chal, theek hai.
The state legislative assembly and the government were dissolved. So effectively, the governor, who is under the control of the president, gave consent to the president. That we've dealt with. President usurped the power of the state government. The article distinguishes between matters covered under the instrument of accession and those that are not. For the president to exercise those powers under a proclamation under 356, that article also required a non-obstante clause in 356. In order to override the non-obstante clause in 370 subclause 1. So he's effectively saying the 370 subclause 1, notwithstanding anything in his constitution, means you can't exercise powers under 356. 356 should have opened by saying notwithstanding anything in his constitution as well
So,
to override this one.
so they are making jurisdictional arguments.
No, these are not jurisdictional arguments. These are textual arguments. This is what the constitution says. You cannot put everything aside. If the constitution says certain things, they are making that argument to say not only are these textually what they are, but the spirit of what you were intending to do is also against the spirit of what these provisions were. And then on CO 273, by which, firstly, President accepts the consent, which is this, where he says, in exercise of powers conferred by clause 3 of Article 370 and subclause 1 of Article 370, the president, this is the president acting as the president, on the recommendation of Parliament acting as state legislature, state legislative assembly, is pleased to declare that as from the 6th of August 2019, all clauses of Article 370 shall cease to be operative. That's what 273 is. So they say that this is completely invalid for the reasons I've already given in relation to 272.
समझ गया.
But besides which, there is no representative body. The state CA does not, the Constituent Assembly does not exist anymore. Only state Constituent Assembly had the power. CO 273 required for the state legislative assembly to be enforced, even if 272 is deemed valid. In the absence of state legislative assembly, that power could not be exercised by parliament. So even if you made it into state legislative assembly by your interpretation, by changing the interpretation clause, you cannot then take that to travel to meaning parliament under 356, right?
समझ गया.
And the two COs together amount to a unilateral reneging of the compact between the Union of India and the people of J&K. the last argument I think I can leave. I am not going into arguments on why they say the Reorganization Act is invalid, uh, because those don't pertain to 370 per se. Those are the
Hmm.
steps that come after 370. But just very quickly,
Because what I'll do is I'll ask you all the questions that have been asked, but I feel some of them you may want to answer them on part two. I'll hold
no,
them
no, it
on
doesn't
to.
matter. I'll initiate that. Let me give a flavor of what part two will be, right? Let's start
Hmm.
that at least so that people then want to tune in into part
Hmm.
two. Yeah, I'm not going to go into the Reorganization Act because that's a different matter altogether. We can perhaps deal with that in the judgment. And anyway, we've taken a long time covering this much.
Yeah.
So
So
why don't
okay.
we go to the
Now,
questions?
yeah. So somebody has asked, wouldn't any clause of 370 be void because it was added to the Constitution Court illegally?
Don't quite understand the question. Or in fact, that may be, if I'm understanding the question, isn't that the entirety of the petitioner's argument that everything you've added in is illegal?
Yeah,
But
and the courts
I
have
want to
deemed it
understand,
legal.
is this a basic structure argument? I don't quite understand.
I
Can you
don't know.
repeat
It's
the
just
question?
wouldn't any clause of 370 be void because it was added to the Constitution illegally?
I don't. 370 is an original provision. It
Hmm.
is a provision from the first day of the Constitution. So there can't be any illegality to an original provision.
Hmm.
And there is nothing added into 370 after that.
Fair enough. That's exactly what I had thought. So, next question. If the Supreme Court had reversed the abrogation of 370, would the Indian government have been justified in stopping all payments to sovereign J&K government? This is a beautiful question. I loved this question. ऐसा डेंजरस
Uh,
क्वेश्चन पूछा है मगर बहुत दिमाग लगा के पूछा है.
no, no, it's an excellent question.
Brilliant
If
question.
the basis for that judgment had in fact been that JNK is sovereign, but then if you do that, you yourself are no longer applying Article 1 to JNK. And you yourself are taking away all the other constitutional orders that you have applied to JNK. In other
Hmm.
words, the moment you take this step, you are saying, please secede. We allow you to.
Hmm.
So it might seem like a harm, we will set you straight, but it's a self-defeating argument.
Hmm. So this question, हाय हाय, ये आदमी को बड़ा दुख दर्द पीड़ा हो रही है, इसके लिए मैं पूछ रहा हूँ. So can tomorrow a Congress-led government reverse this abrogation of 370? Is it possible to permanently disable any activity on 370 hence further? I mean, basically, isn't that part two of the entire podcast that we are going to do, explaining what the government and
We
the
will,
courts have done?
but in short, what we are saying today, and this is why I read that bit uh, from 250 and from where I'd said that if any particular action is already taken under a legislative, in fact, forget about the Congress government in power in the center. When you have a state legislature which is back in power, it can start reversing steps taken and recommendations given. Correct? But they have a problem that every step that has already been taken during the pendency will be accepted.
Hmm. Because that's what the court has basically put a
No, that's what the
stamp on.
article says. Article 250 subclause 2 says that whatever you've done already will be accepted.
Hmm.
This is where that argument comes that how could you have done something so permanent?
Hmm. अब हो गया ना
In
अभी क्या.
any event, today, when a JNK government comes back to power, it comes to power under the Indian constitution. There is no JNK government constitution to come to power with.
Hmm.
And so your powers now as a state legislature will be circumscribed by the actions taken under the Indian constitution by the state thereafter.
समझ गया, समझ गया. Okay, next question was, given government of India was planning this for at least 6 years before the abrogation of 370, do you see any sign of government of India working on the UCC and Waqf board also? हाँ वकील साहब, आपको कुछ पता है?
Look, I don't know where you get the 6 years. I actually think, and I'm not, I think they tried the Sida approach first. They got into power. They wanted to share power. And they must have got a feel for how bad things are with Mehbooba Mufti.
Hmm.
That they must have thought that if 370 has to be repealed, then we have to raise the conversation. But they must have realized you can't even raise this conversation.
Hmm.
So don't even give an indication of this outside of your manifesto, right? And otherwise
Hmm.
keep quiet on it. During that preceding period when they were jointly in power, they kept talking about 370 is not on the table right now.
Hmm.
Uh, so they must have realized pretty soon that now we have to do it in the other route.
Hmm.
But perhaps they'll do it. Perhaps they'll do all of this. I've
Yeah.
seen from the questions. I understand, and I apologize to the listeners and to the viewers. This was highly technical, but it needed to be highly technical if you had to
No, but
understand.
honestly, I think it was quite obvious how the government did it. Now, the way we explained it, right? Now, people actually understand what was the rationale of the government. That is why I use that Chacha Bhatija analogy and try to dumb it down.
Yeah, yeah,
That's the
but
perfect analogy because the government literally thought like that.
but it's a perfectly fair thing that for viewers who are perhaps for the first time being exposed to these constitutional provisions, they're actually very difficult. They're actually very complicated,
And they can
and
watch it or
and it,
listen to it again, right?
yeah. So maybe they you can have more sort of reflective questions in part two.
Hmm. So we can do that, right? So these were the questions that were asked, and there was one more question that was asked, that there is a lot of apprehension with respect to Article 370 in different communities that have voiced concerned about corrupt politicians, builders, or mafias coming up. So do you think what do you think that has to do with this entire kerfuffle? Do you have any
Uh,
opinion on that?
have been quite clear from the start of this podcast. I was looking only at the constitutional
Yeah.
mechanism by which this was done. I think what they're talking about is that the state of governance post 370's abrogation itself has seen some negative outcomes.
Hmm.
But those negative outcomes don't have a fallout on the constitutional mechanism.
Yeah,
So I'm not going to
and the
comment on that.
corruption argument is such a straw man argument, as if corruption did not exist before this. I mean, to this
Let
person
me
who
put
has
it
asked
this
this
way:
question,
corruption in India does not amount to a breakdown of constitutional machinery, because if
nothing.
it
It
did,
has,
then every state government was gone.
yeah, nothing. And not only that, you have no idea how corrupt the governments were there, and how much two families, how much wealth two families have amassed. So the less I say, the better. The less I say, the better, because at the end of the day, मैं ज़्यादा बोलूँगा तो पता नहीं बात कहाँ निकल जाएगी. The things I know, I can't say here. Let's just put it this way. So, anyways, so what we'll do is, Nikhil, actually, Almed, this was amazing. Now even I have clarity, because देख मैं भी पढ़ता रहता हूँ, मगर मुझे भी कुछ चीजें नहीं समझ पड़ रही थी. तो आज एक्चुअली सुन के मुझे परफेक्ट क्लैरिटी मिल गई कि what the hell the government did, how they looked at it, what legal precedents were set to go about doing it. And good, now we also dealt with the challenges sent from the side that was opposing the abrogation of 370. So we have done that. So now we have actually now have the perfect platform for
No, and I,
Tuesday.
and I and I hope there's an appreciation amongst everyone that the arguments that were being raised, because a lot of the people who raised these arguments, who were arguing on behalf of petitioners, were basically being looked at as meddlesome people. But they had a very, very good and strong and solid constitutional basis to raise these questions. These are strong constitutional questions. Kushal, these are not minor arguments.
Hmm.
Because if you can do this, then the words of a constitution don't matter. You have to answer all of this properly as the court. You can't let all of this go away. That's in part two. But
Hmm.
don't think that these are light arguments that were raised. They're very strong arguments.
Fair enough. We'll leave it at that. We'll wrap today's discussion over here. Nikhil, good job. I'm actually मेरे को बहुत begrudgingly बोलना पड़ रहा है कि I'm proud of you. तूने बहुत अच्छे से explain किया, but ज़्यादा serious नहीं हो जाना. बाद में मैं तुझे गालियाँ दे दूंगा. But yeah, this was really informative. I learned a lot. So as always, thanks, buddy.
See, this is why I told you right at the start that gotta do this in two parts. I can't rush
Yeah,
this.
yeah. This was brilliant, boss. This was brilliant
No,
because
it's not brilliant. It's just enumerative. That's all it is. I'm just
no.
explaining.
I am so proud of the government of India, the way they did it. I am so impressed by them. मैं बोला यार मान गए उस्ताद, क्या शातिर दिमाग है. ऐसे किया, ऐसे किया, ऐसे किया. It's brilliant stuff.
नहीं मतलब देखो ये चीजें ना ओवर अ पीरियड ऑफ टाइम थोड़ी ऑब्वियस होने लगते हैं बिकॉज नेक्स्ट टाइम जब बात करेंगे आई विल शो दैट देयर वर जजमेंट्स ऑलरेडी हैड इंडिकेटेड वेयर थिंग्स वर स्टार्टिंग टू हैपन राइट लाइक द इंडिकेशंस वर देयर यू कुड डू इट दिस वे यू कुड डू इट दैट वे What are
Hmm.
they doing? Like, look, the one magic step is what? The one magic step is, how do you have the Constituent Assembly read as Legislative Assembly? Now, they knew they can't do it in Article 370, subclause 3 by amendment of 370, subclause 3 itself. So they
Hmm.
choose to do it in the interpretation clause, right?
Hmm.
And then they had the last bit to justify, which is, we're doing all of this when a 356 proclamation is in effect. Can we do it when a 356 proclamation is in effect? That's the thing.
Got it. And that's the crux of the issue. That's the
Yeah,
crux. And
that's the
that's
heart.
what the courts dealt with. The
That's
courts
what they did.
basically dealt with exactly that issue. That's the perfect place to end. Nikhil, as always, thank you very much. So I'll see you on
Thank you so
Tuesday.
much, Kushal. This is actually a lot of fun and allowed me to sort of dig much deeper into the judgment as well. I enjoyed it.
I told you, see, when we do the podcast, I've told you, you have absolute freedom to take it wherever you like to. I
No, no,
love these
but
kind
I
of.
do appreciate that for a lot of listeners, this one will be very dry, very difficult to at times to follow, perhaps even a boring podcast. This one was meant more
ऐसा नहीं है.
for.
ऐसा नहीं है. I have to appreciate my listener base also, whether audio or YouTube wala. I say this with a lot of pride that on this podcast, at least, we have created a system where a certain level of audience comes, a highly evolved audience. The questions were so intelligent. See, the questions show what kind of a audience you have. And यहाँ पे लोग आते ही उस टाइप के हैं, तो वही लोग होते हैं जो मैटर करते हैं. एंड आई से दिस विद ऑल सीरियसनेस that every time I do these kinds of podcasts, there is apprehension many times from the guest perspective, and I always tell the guests, trust my audience. My audience is very sharp, very smart. They actually can ask questions.
No, no,
And
I don't dispute sharp and smart and all of that, but it's complicated stuff. So it's actually quite remarkable that they'd want to keep up.
yeah, they will, and you'll see they'll come back on Tuesday again. They'll come back
Yeah,
on
yeah,
Tuesday.
I'm really hoping to hear that. I mean, if people have heard it in that time and they really want to sort of engage with it, come back with more and more questions, guys. It'll be a lot of fun.
Yeah, and we'll do exactly that. So, guys, I'll see you guys again on Monday. To dekhunga hi, but as for this podcast, the part 2 will be on Tuesday. But before we wrap it up, once again, these podcasts take a lot of effort. So, if you can support the Cārvāka podcast, there are multiple ways to support it. You can buy merch on kushalmehra.com. You can become a member on YouTube, Patreon, Fanmo. If you can't do any of this, you're an audio listener, just leave a rating on Spotify, iTunes, whichever platform you listen to. Leave a rating over there. If you're watching this on YouTube, like the video, subscribe to the channel, leave the comments in the comment section, and go follow Nikhil on X. I've left his Twitter handle, X handle, in the description of the podcast. This podcast is built for these kinds of deep dives, long discussions, which basically no other podcast. I say this with a lot of pride and humility at the same time. Basically, no other podcast does this. I try to do this because I love this, and maybe I did a few things in my earlier life that has given me the buffer to experiment with these things. So I hope you guys appreciate it. I will see you guys next time. Until then, namaste, take care, bye bye.